Good morning. A warm welcome to the Humanist community in Silicon Valley Sunday Forum, to those joining us on Zoom and to those joining us on Facebook and in person. My name is Ray Sunby, president of the Humanist community. The Humanist community is a chapter of the American Humanist Association. Humanism is a secular and reality-based philosophy of life that affirms our ability and responsibility to lead ethical lives of personal fulfillment that aspire to the greater good. We value freedom, health, happiness, fairness, compassion, and using science and reason to acquire and apply knowledge. If these words describe your thinking, we invite you to become a member of the Humanist community if you have not yet done so. Membership forms are available on our website at humanists.org. A special welcome to those who are with us for the first time. We invite you to continue listening and participating with our weekly forums and other events. You can find all our events listed on the website, humanists.org. Please aid us in continuing to present these forums by donating to the Humanist community. You can find out how to donate to our organization on our website, humanists.org.
Thank you, Ray. My name is Alex Havasi. I'm vice president of the Humanist community. Okay, today Vic Schachter will provide an update on his efforts to promote fair and effective dispute resolution in countries with heavily backlogged courts, and thereby promoting access by undeserving populations to fair and timely dispute resolution. He'll share some of the unique challenges to do with his work during the pandemic, as well as the prospects for continued future efforts in Asia, Eastern Europe, and South America, and Africa. Victor is the founder and president of the Foundation for Sustainable Rule of Law, or FSRI, a non-governmental organization dedicated to establishing sustained mediation centers globally to achieve timely, fair, and peaceful conflict resolution. He's served extensively as a mediator and as an advocate representing clients over his 50-year career. In addition, he's led rule of law and related educational initiatives promoting judicial reform and alternative dispute resolution. He's been honored as a California Lawyer Attorney of the Year for his service to in judicial reform and mediation building back in October 2020. He received the Mediation of the Year Award from the Mediation Society of San Francisco for outstanding contributions to the field of mediation. His work has been reported and cited in numerous publications. So please welcome Victor Schachter.
I don't know if you want this.
Yes. You turn that on.
Okay. Good. Can you all hear me all right? All right. And if you can't, just raise your hand and let me know. Let's see here. Get a couple of things in order. First, let me thank you for re-inviting me. That's always a good sign when you're re-invited to come and speak with you again. I see actually a couple of familiar faces that I saw a few years ago, I think. I was last here in May of 2019. So that was just before the pandemic hit, as I recall, about 3 years ago. And at that time, I talked to you about the work that our foundation was doing. And it's been a very interesting period since that time, because we've dealt with all the challenges of the pandemic and the challenges of, as I will talk about, some of the developments around the world and the countries that we've worked with that have been very formidable over the years. But I'm happy to report to you that we've had a very successful adjustment during the pandemic, as I will describe, because of the nature of the work that we do. What I'd like to do is speak to you about 25 minutes or so and give you an update as to our global efforts. First, perhaps a brief review for those of you that may not recall or were not here before of what we do, what our mission is, what we've done, and then to update you on those activities more currently and what has transpired over the last couple of years, or several years actually, since I spoke with you last time. I do want to emphasize to you in describing the work that we do, what our mission is, because, and actually I have, for those of you that are interested, there's a handout on the table, a one-pager that summarizes the mission of the Foundation for Sustainable Rule of Law Initiatives, FSRI. FSRI is the way we refer to it by its acronym. But for those of you that are unfamiliar with that mission, let me just briefly describe it, and then that will help you understand the work that we've done. Around the world, as you can imagine, there are many dysfunctional court systems. Apart from all our challenges here in the United States with our courts, the fact of the matter is, in many countries, it's far, far worse. India, for example, has backlogged 32 million cases. Brazil, which is 1/4 of the population of India, has over 80 million, 3 times as many backlog cases. Now, what does that mean to people who have disputes? What it means is they don't get, particularly those that are underserved, as was mentioned in my introduction. We address and focus on underserved populations, people who don't have a great deal of money or a great deal of power or a great deal of access to the court systems, which are backlogged, can't afford to go to litigation, or can't afford, in many cases, 20, 25 years of litigation before they get a resolution, if they get one ever at all. So what we designed is a concept at FSRI that we would agree upon invitation, which is really critical to emphasize, upon invitation from a host country, usually the highest court of the land, Supreme Court of India, or the highest courts of Brazil, or in Eastern Europe, where we've worked, in Croatia and Bulgaria and the Republic of Georgia. On invitation, we will come and work with those folks in the high courts and help them set up systems of mediation. That is to say, all those cases that are backlogged, we will work with the judges and train them to refer those backlog cases into these mediation centers, which we will help them establish. So we work with the judges in training them how to make referrals of their backlog cases. And it will surprise you to hear they're reluctant to do it, even though they have all these backlog cases. They want control of their cases. They're worried about the quality of their cases. We've got to press them to do it. Then we've got to set up the centers themselves. And this is the key of our concept at FSRI. We don't go like the State Department or USAID, the Agency for International Development, with any preconceived notion of what these centers should be. Our goal is to go and learn what are the dispute resolution procedures that exist already in the country. Every country has some form of dispute resolution procedure. So if we can tailor what we design for them as a mediation program to what their existing culture is, the chances are that when we leave, unlike many of our federal government programs overseas, unlike those which collapse usually after the U.S. personnel leave within a year, we will see our programs continue because they will be embraced within the culture to support the program. So we operate basically in a 3-step process. Upon invitation from a host country, we will come in, and the first delegation that we send, which is comprised of, or by the way, we're all volunteers. None of us are compensated for our work, period. And I have, if you look at our website, you will see high court judges of the United States appointed by the president that are members of our board, our advisory boards, who have traveled with me, very fine lawyers and mediators who will travel unpaid, uncompensated, giving up a lot of income while they're gone, and then volunteer lawyers, all of whom go in these delegations. So we'll go first upon invitation and do nothing more than assess what is going on in the country, what works, what doesn't work, what might be good recommendations to develop a successful mediation program. After we do that, we write up an analysis, usually it's about 15 to 20 pages long, with recommendations as to what we recommend they do, expressing our willingness to come back if they accept those recommendations to help them set the program up. What kind of mediation program they should have. How do they get their judges trained on making referrals? How do they train mediators with the skills? And I'll talk in a minute about that. What's different about mediation skills than litigation skills? Totally different skill set. How do we train lawyers and judges who want to be mediators to run these sessions and get resolution in these countries where we work? We write up our recommendations. And the second phase, if they accept and want us to return, then we will come back and help them set up the systems. We'll train the mediators, we'll train the judges, we'll set up the mechanism, the physicality, the physical mediation center. I'll digress for 1 second. One of the first cases I had, or the first mediation centers I worked on in the early 2000s, the Chief Justice then of the Supreme Court asked me to go work in a mediation center called FSRI in Delhi. And when I got up to the center, I looked around the center and it was just filthy with garbage. Monkeys were running around all over the place, defecating, stealing food, people waiting hour after hour, day after day to get their court hearings, biting people, stealing their food in many cases, or not many cases, in several cases. And I turned to the chief and I said, Chief, of all the places you want me to start to set up a mediation center, can't you pick a place that might be better than this particular location? And he smiled somewhat wisely and said, Mr. Victor, they never could pronounce my last name. I can't blame him for that. Mr. Victor, he said, if you can show that you can do it here, then you're going to be able to show every other jurisdiction in this country of India of 1 billion people that we can do it elsewhere. Now, they don't teach you in law school how you eliminate monkeys from mediation centers. That's not part of the coursework that we do. And if you'd like to know, ask me the question. I'll tell you how we got rid of the monkeys and then started to clean the place up and set up a mediation center, which still exists today in Delhi, as well as many others. And in fact, in India, they have handled with the mediation centers we work with and others that have started well over 200,000 cases. The settlement rate of these cases is well over 60%, and that includes some of the most difficult cases in the world, matrimonial cases, which are highly emotional and contentious. So all of this was kind of part of the experience of what we did, and those centers are still going today. So the second phase is then to implement it, and the third and last phase, as you would see if you go into our website and see the little video that's there, is we return from year to year up to the time of the pandemic, from year to year, upon invitation, critique what's being done, and as they request, continue to work to improve the programs and refine the programs over a period of time. So that's basically what we do. Now, what's the relationship of all of what I've described to why I'm here to speak to you today? We've done this work beginning a number of years ago. We're just actually celebrating this year our 10th anniversary, which I'm very pleased that we've been able to survive and thrive and continue this work through these last 10 years, and particularly through the pandemic. What's the kind of the concept here? Well, one obviously is providing access to just and fair dispute resolution. The other is this concept of rule of law, which you've all heard about. It's been part of our toxic national politics and state politics and our midterms and all the rest that's been going on in our chaos here in the United States. Well, what is this? What are we talking about here? What does this all have to do with rule of law? Well, in India, as well as in other countries, in Brazil as well, actually, and several other countries, if people don't have access to dispute resolution in what they think is a fair and an efficient way, what do? They engage in self-help. They go out, they hire people, strong-arm people to collect loans and break arms. They bribe people. They completely disrespect what exists of the judicial system. And they certainly feed a whole corrupt system of trying to keep their rights and their issues in some perspective to get them addressed, because they have no access to a rule of law, a system where all people are treated equally under fair rules, and they can expect that they're going to get, as the UN Declaration of Human Rights spoke about, the right to a hearing and a fair trial, one of the most basic human rights that exist. So there's a direct correlation between having an orderly rule of law and peaceful dispute resolution process and the violence which ensues and the chaos which ensues when you fail to have such a system. So we view our work at FSRI as being integral to providing people with this opportunity to get their disputes resolved in a peaceful, effective, and very, very caring system. Now, how does that play out? Well, just to again give an example of a place we spend a lot of time in, although I'll talk about some others. In India, for example, the criminal conviction rate is 6%. Think about that. 6%. That means that 94% of those people charged with crimes never are held accountable in a court of law. Well, what do you think that does to your population? Do you think that encourages people to abide by the law? Or does it encourage them to steal and to defraud and to engage in corrupt activities of all kinds? Well, of course, it's the latter. So the relationship between providing a system of dispute resolution and the rule of law and compliance with the rule of law and respect for the judiciary and the governmental process are directly related to one another. Now, what is there about our process that is kind of unique? Have any of you, I doubt this is the case, but have any of you been involved in a mediation of a, I'm not going to ask you any details, just I'm curious, have any of you been involved in a mediation of a legal dispute as distinct from court litigation? One person, two people, good for you. Three, even 3.5, maybe 4, 5. Well, that's great if you have. So if you've been through the right experience of what a mediation is, I want to explain to you how it differs from litigation. Now, I think it was mentioned in my intro, I spent 5 decades, 50 years. I started when I was 6 months old, okay, as a litigator. And I loved litigation. The fangs would come out, and I was very competitive and adversarial. I had quite a successful career doing it, a good following with clients. But when it was all over, it was a right, and not right. There was somebody who was found to be legitimate and right in their claims, and the other party was the loser. There was a winner and a loser. And it was a very contentious process. And any of you that have been in litigation in marital affairs, or even business affairs, or in property matters, or real estate matters, or employment disputes, or sexual harassment claims, you know how painful that process is, and particularly how bitter and upsetting it is if you lose, much less often the emptiness of what you win at the end, which may be some money, but not much more in most cases. The mediation process differs from litigation that goes before a third party, a judge, to determine who's right and wrong. The focus of mediation and the work of our NGO, our non-governmental entity here, is that the skill of the mediator is to get to a win-win situation. The goal is not to prove who's right or wrong. As I say in all the mediations that I do today on a voluntary basis here as a private mediator here in California, I want the parties to understand we're not going to prove the other party's wrong and you're right. That's not why we're here. What we're here, as a very famous Persian poet said in the 12th century by the name of Rumi, we go beyond rightness and wrongness. There is a field beyond rightness and wrongness, and I will meet you there. Just let that sink in for a second. It's not a question of what's right or wrong. It's a question of understanding, identifying what the legitimate interests of the parties are, and then working out a resolution they can live with going forward. That's the beauty of the mediation process. That's the skill of what a mediator does. So in that regard, that's our mission. That's our work, is to train people on those skills, to have them run these programs, and then carry them out. Now, when I spoke to you last 3 years ago in May of 2019, I spoke to you about a lot of the work that we've done in India, quite a bit of work, I believe, at that time as well in South America, and also in Eastern Europe, in Bulgaria, Croatia, and the Republic of Georgia. Since that time, and before the pandemic came about, we've done a lot of work. We returned to Calcutta and Bangalore in December of 2019, just before it all hit. And we've been to some various other locations, but it's been primarily, since the pandemic, it's been done virtually. Now, before I talk to you a little bit about the work that we do, I want to remind you of something that's very close to all of you, that I think is worth mentioning as to why I'm here speaking to you today. One of the books that I really enjoyed reading, which I suspect many of you are familiar with, is Roy Speckhart's book on creating change through humanism. You may be familiar with it. And if you haven't read it, I encourage you to read it. It's a wonderful description. It certainly was my exploration into what humanism was about as I grew away from formal religion and felt much more about humanistic values. It really resonated with me. And as I think about the work that we do at FSRI, and the reason I'm coming to speak to you, there are certain pillars of humanism that Roy has spoke about in his book. One of them, the strongest pillars, of course, you know, is empathy. That's one of the 10 commitments. The other is compassion for humankind and the world at large. This is all discussed in his book. And that humanism means seeking to better oneself and society and enjoying the experience along the way, which I must tell you, on a personal level, myself and my wife, who has supported me in these efforts and travel in these countries as well. In fact, oftentimes they're more interested in seeing my wife than they are seeing me. When I don't show up with her, they ask me, "Where's Madam?" Which I have to reconcile myself with. But we've developed these really enjoyable and worthwhile relationships that have been very rewarding. But the other concept that Roy Speckhard spoke about is working to benefit society, maximizes individual happiness. And the 10 commitments that he identifies, a few that I want to mention, most of which are around 167, 168 of the book: altruism, caring for the world, empathy for others, global awareness, and service. These are all elements that are described as part of the 10 commitments in the book. That's what we're about at FSRI. I suppose that's the reason I've been invited to come back and speak to all of you. And my transition from litigator with the fangs and all of that business, which again, I enjoyed, but it was part of a very different journey, transition to mediation and setting up these mediation centers has been absolutely wonderful. And I am privileged. I just turned 80. I'm privileged these last 10 years, actually more going back early when I started all of this, before I started FSRI, to enjoy this work, to promote this dispute resolution, and to develop these friendships with judges and lawyers and mediators all around the world. For those of you that are interested, I have a copy on the side here, an article that was published in the American Bar Association. You feel free to take a copy, A Personal Journey from Law to Retirement. My so-called retirement, this is described here somewhat euphemistically. You're welcome to take a copy, and it describes to you how I transitioned from quite a lucrative and satisfying litigation career into something that's become a life work that I hope to be doing as long as I am healthy and able to do so. So that's a little bit by way of background in terms of what we've done. And what I want to do is briefly share with you some of the updates of what our activities are, particularly in the post-pandemic environment, since I last spoke with you. First, let me comment that the last time I discussed with you our work, we had been going with delegations to various of these countries that were mentioned in South America, in Eastern Europe, and in India, in Asia generally. And what we've had to do because of the pandemic is switch to a virtual model. And that has been the dramatic change. So that what we have done, for example, where we would meet with mediators and judges to train them on referral techniques, mediators on mediation skills and refining their skills, others, administrators of court programs, court annexed, court referred cases into the mediation centers, that has all been done virtually. And I'm happy to report to you that despite all the cultural differences between our country, among our countries, that they have embraced the concept of virtual meetings, and we've been able to extend this relationship in amazing ways. Two examples I want to give you that are all bringing you more current. In India, we established what we call reflective mediation sessions. These were meetings with the leading mediators in India, virtually, every month for 10 months to refine their skills, to coach them, to help them address their challenging cases. And these sessions have now been continued by Indian mediators and lawyers beyond the 10 months that we did it. So this 10-month program to build sustainable ongoing contact and support of the program has been a huge success. It's been done virtually. In Brazil, where we had, I mentioned to you, the 80 million cases that are backlogged, we did the same thing. We created what we call these reflective mediation centers or sessions. The mediators would come, they would talk about their most troubling cases, their most difficult challenges, and then we would discuss together how to address those challenges and reach a resolution. And of course, we continued and developed our personal relationship in these countries. So these reflective mediation centers in the post-pandemic environment have been highly successful, and they are continuing, and that was our goal, to continue these sessions on their own, inviting us from time to time to come back, but they're running those sessions very successfully. In addition, we have coached judges, we have coached mediators on a one-to-one basis in various of these countries on systems to improve delivery of their skills and the upgrading of their quality and their skills. In Croatia, in particular, some of you may remember a couple of years ago, Croatia suffered through 2 earthquakes, but one particularly bad earthquake. The entire mediation centers that we work with there were almost completely destroyed. And we were able to raise funds, support them to get back on their feet again. And they've got a very successful program that's resumed working in Eastern Europe, in Croatia, very successfully. We've worked with law schools and training future lawyers, so they're trained not only to be adversaries and know how to go out there and beat their opponents in an adversarial proceeding, but we've trained them on the skills on how to provide to their clients an expanded and profitable service of mediation, getting their clients to resolution, not just to a win-lose situation, but a win-win situation. And we've supported competitions in these countries, mediation competitions at the law schools to support all that. The last element that I want to talk to you about is what we call ODR. ODR stands for Online Dispute Resolution. And as you might imagine, the most successful mediations were mediations that were face-to-face. And we were very skeptical as to whether we could do this in some other way, with the parties unable to physically come long distances, unwilling, understandably, because of the infectious nature of COVID and the rest to come. Could we do it online? And I was one of the biggest skeptics of this because, as you can imagine, when you come in as a mediator, you're not known to you might be known to the lawyers that are there to represent their parties, but you're not known to the parties themselves. So you've got to build a trust. You've got to build a rapport. That takes usually, most of my mediations go at least a day, if not multiple days. And it takes several hours to build that trust when they come in with anger and hurt and frustration about what they feel they've been victimized by, or what they've been exploited by someone that's making false claims against them. So all of this requires a lot of work, and I was very skeptical that we could do this online. The short end of this story, and I'll leave it to your questions rather than expand on it too much right now, is that we found that as people got used to Zoom and online, that we could, using the tools that are available on these various virtual mechanisms, we could conduct mediations online. We could set up private caucuses with the parties. We could set up joint conferences with the parties. We could meet and discuss approaches and how to get beyond impasse, which almost all these cases quickly go to an impasse, and use the techniques that we have learned on how you get parties when they dug their position in. How do you get them to move to a resolution? That we could do this online. So what has happened since I've spoken to you last is that the vast majority of mediations in the United States today, as well as the work that we're doing overseas, the vast majority are actually through ODR, online dispute resolution. So we've been training lawyers, we've been training clients, people who are the disputing parties, educating them about how to use online dispute resolution. And we have various techniques to do that. I'll mention just one to give you an example that we use very commonly is before the mediation takes place online, we often will meet, at least with a phone conference, if not a Zoom, a pre-mediation conference with the lawyers to discuss the process, sometimes with their clients, so they understand what the process is, and they're not suspicious of what's going on, and they're not feeling no wool is being pulled over their eyes, and they begin to trust the process, and then we work into the process with them in advance, and then, of course, they see how it plays out when we actually do it on these various Zooms and private meetings. So that has been a major change in the whole mediation process. And for those of you that may have done it on a personal basis in your past, I can tell you now it's become so popular and so successful that we're finding that people are opting for online dispute resolution because it's so convenient. And so long as they don't step away from the Zoom conference where we see them walking around in their underwear, we normally see them in some kind of a collared shirt, and they're prepared. And it's a great opportunity to relate to people and to really get to the underlying issues of concern to them. So that's the major change, or those are some of the major changes that I wanted to tell you about. And I think what I'd like to do is close by talking to you about some of the challenges that we have experienced going forward. I think that would be an appropriate basis to talk about what we see going on, because the challenges remain. For example, I've been recently engaged in Pakistan in a way I never had anticipated. I ran into an absolutely fabulous woman, a doctor of law in Pakistan, who I met when she was here on an internship. She's a phenomenal person, and she's invited me to work with the judges. And I've met the judges on Zoom, trained the judges. We've proposed various programs there. And now she actually wants us to do a broad range of judicial referral training to many of the judges throughout Pakistan. Well, any of you who have read the paper, you know what's going on there. There's a tremendous political crisis going on. The Prime Minister, former Prime Minister Khan, has been thrown out, and as a result, he's trying to make a comeback, and the country's very torn, much like we were in recent elections, is very, very torn on where it's going. And the judiciary has undergone a lot of tumult. So clearly those political realities we have to deal with when we go to a country, and it's held us up. In Bulgaria, the judge that I worked there, his name is Evgeny Georgiev, a wonderful, courageous judge who has challenged the system in Bulgaria to bring in systems of integrity and dispute resolution. He has invited our organization, FSRI. It's a wonderful opportunity, and we've put a proposal together, which they've accepted, to train almost 1,000 of their judges, almost all of their judges in the country, on how to do effective referrals, how to use the mediation process and the mediation centers that have been set up in Sofia and various other places in Bulgaria. The problem is there's such dissension between the factions. Does this sound familiar, right? In the parliament, that the parliament is been engaged and disengaged and in chaos. And we cannot, it's a civil law jurisdiction, which means we cannot implement this program until a law is passed. Unlike our system, which is common law, case law, their system is legislative law. So we got to get a law passed before we can go forward with that program. So we've got a proposal. We've got the judges that want to do it. We've got mediators and lawyers that want to do it, but we're waiting to overcome the political challenge that we have to get the legislature to enact this law, which we think in the coming year will happen, but we've got to watch what's going on in the political process. And lastly, I'll mention the ongoing challenge. Heaven help us with these lawyers, of which I was one, right? To them, ADR, alternative dispute resolution, that's if you will, the category that encompasses mediation, arbitration, or an alternative to litigation, ADR. To most lawyers in these countries, ADR means awful diminution of revenue, okay? And it's understandable. They're fearful, particularly in the lower level bar, not the high level where they get high value cases for which they're well paid, but the vast majority of cases which represent poorer people. These people churn these cases. And by churning these cases, they make money. So when I come from the United States as an American to one of these countries and I say, you've got to try this, they nod their head and they say, what a great idea it is. Then they go out and they churn the cases because they don't want to lose their revenue that they need for themselves, their law firms, their families, except if they're a very high-level practice, which they have high-level cases. And of course, they're less concerned with loss of income because they have a very, very strong revenue stream. So when I go to a country, I won't mention one in particular by name, but I'll mention the area in Eastern Europe, and I say, look, let me tell you something. You want to provide this service to your clients, not just to litigate, not just to beat up the other side, but to reach a resolution, go on with your lives. And if it's a marital situation, maybe get a reconciliation of the family. And if we have time, I can tell you about some of these amazing results that have come out of reconciling disputing families over property disputes over 20 or 25 years of fighting with one another. And now they come back together in mediation, something a court can never give you. And they'll raise their hand and say, look, my client wants to beat up the other side. My client wants a judge to say, you're wrong to the other side, we're right, and we're going to rip your nails off one at a time, all 10, to make sure you suffer for what you have done to victimize my client. So we have to get the mindset of lawyers to understand this is a process that works for their clients to resolution, not just litigation where there's a winner and loser. It's a win-win. 2, that you're providing a service, and 3, that it can be very profitable. And that's a whole other subject. If you have questions about it, I'll be happy to comment on it. But I will tell you, in my practice in Silicon Valley before I retired, our work in mediation, this is where we represented clients, not where I was the mediator, but we represented clients in mediation, which I did many of those cases as an advocate. We charge very handsomely for our time and make a very decent living out of that. And our clients are very grateful because we get them to resolution without 10 years of litigation and appeals and the possibility of losing what they won or losing again what they lost before. So this is a real challenge to get the mindset of the advocates and the mindset of the clients of the companies out there to accept this concept. And if you have questions about this, I can talk about some of the things that we've done in order to do that. So I think I've used about the time that you've been patient enough to listen of an overview of what we've done. I've given you a little bit of an update with online dispute resolution, our continuing work with the reflective mediation sessions, the coaching that we've done with mediators around the world to bring you up to date. We are alive, we are well, we are aspiring, endeavoring, and yes, we are prospering in the process of the work that we do, but we are also very challenged as we look now to yet another year of the pandemic as to what we're going to be able to do in the future. And I will close by saying that it is my intent now, absent a new stimulant out there, a new COVID that will prevent us. Based on where things are now, we are planning to return. We've been invited to go back to India. We've been invited to come back to Brazil, and we've invited to come back to Eastern Europe in order to continue personal delegations and work. And right now, the environment is sufficiently safe that we've got people willing, including myself, that are willing to go there and do this work. So we're very hopeful we'll be able to resume these personal delegations. So with that, unless there's some other way that you wanted me to proceed, what I'd like to do is open up to questions. If people have questions that they would like me to address about any of the work that we're doing, please don't be intimidated by the so-called expertise that I share with you about the work that we're doing in mediation or in this work overseas, or about what you know or don't know about any of these countries. Feel free to raise any questions that you have that you might be curious about, and I'll turn it over to you for any questions that folks would like to raise.
Thank you, Victor. So, Jerry.
Yes, sir.
So I'm Jerry Grass. So you said you're attempting to have a win-win solution. In how many of the cases did both sides agree that they won?
Very interesting. I can answer you. I assume I don't have to repeat the question. That with the mic, you've got the question. Good. So there are two ways that we know. One is as part of our program, we ask the parties and the lawyers to fill out an evaluation of every mediation that they do. So they give us in confidence. They don't have to sign their names, although most, I got to tell you, people are pretty blunt about it. They say what they really think. So we know from them whether they feel it's a satisfactory process, and they view it as a win or not a win. The second thing we do in our system, in all our programs, once the parties reach a voluntary resolution, and of course the mediator's role is not to tell the parties what the resolution is. They've got to decide what they want. It's incorporated in a written memorandum of understanding. That MOU is then taken to the court that had the case. The court turns that MOU into a judgment, a final judgment, which means a litigation is over. It's done. They cannot appeal any further. It's a judgment. The only thing they can do is, if a party doesn't abide by the agreement, they can go in to ask the court to enforce the agreement if it's been breached. And that happens rarely in the cases that we have. Why? Because the people that are participating have voluntarily reached the resolution, and it's their resolution, not the mediators, not a judges, not somebody on the outside who doesn't understand the problem, but they who understand the problem. That's been very, very successful. That's how we know. Good question.
Good morning.
Morning.
First off, what you do is amazing and wonderful. I wanted to compliment you on that.
Thank you.
And I hope I look like you look when I turn 80.
That's at least 50 years from now, right?
Oh, yeah. But I do have two questions.
Sure.
One is, when you have a country with, say, tens of millions of backlog cases, I'm guessing there's some of them that are not deemed appropriate for mediation. And I was wondering if you have a filtering process, and if so, could you describe it? Question two, how did you get rid of the monkeys at the Indian Mediation Center?
Okay, all right. I'll not forget the second question for sure. So I'll start with your first one. We do sort the cases. There are certain cases, for example, that are more ready for mediation. Now, there's nothing that we reject outright because I believe mediation is a process that works in every kind of case: intellectual property, rental disputes, discrimination suits, employment disputes, you name it. All of that really works very well. But for example, in a marital dispute, if we're dealing with multiple child custody issues, if we're dealing with highly emotional parties that are uneducated, if we're dealing, as I had in one of my first cases in India, with a woman that comes in and she's obviously been physically battered, beaten, as well as mentally abused. We have to, and we've got a criminal proceeding going on for assault and battery and possibly a rape by a brother of the husband. We have to figure out, is this suitable? Are the parties really ready to try and work out these resolutions? And generally, the answer is yes, they are, if we can get them to understand what the process is. Now, there are some cases that they're not. And in many cases, particularly the ones where they say, I want the judge to beat up the other side and tell them that they're wrong, and I want every penny I can get out of them. Sometimes we have to let a bloodletting. We let them go litigate for 6 months or a year, or we let them bring their motions and they find they aren't successful in all their pretrial motions and they get beat up a little bit. And then I get a phone call that will say, we'd like to reconsider whether we want to go forward. So these are qualitative judgments that we make in every case. And oftentimes we'll interview the parties in advance before we schedule a mediation. This is what I call a pre-mediation conference call to assess whether their mindset is right, to make sure they understand we're not here to say you're wrong, or rather you're right and the other party's wrong, but what this process is about. And once we know they understand the process, the likelihood of the process being successful, whether they settle is a different story, but they're being satisfied that it was a fair and effective process. That is pretty high. Did that in part answer your question? And we've handled, I want to give you just one example that I can't resist, just to give you an idea of the beauty of this process. There was one case, it involved a large estate. The grandchildren were litigating the matter. This happened to be in India. It was one of my early cases there, or one of their early cases. The 20, 25 years, they're fighting about this property, a massive property, which in India, as you can imagine, is quite a special thing. There was an estate and there was land. One faction of the children wanted to develop the property into a business, to run a business and to be a successful, profitable business. The other faction of the family wanted the property to basically be a residential place for their extended family. And they had been fighting for over 20 years about the rights to this property. And of course, the dissension between, the tension between them, they completely alienated one another. That was also an issue. So I'll tell you what the mediator did with a little facilitation from me to just give you an idea of the beauty of the process. So while they're fighting about this in court, who's right, who owns this, who has title to this, whatever it may be, we brought the parties together and we got the people that wanted the house as a residence for their extended family to divide about 2/3 of the property for residential use. And then 1/3 of the property and the land was converted into a business in which both parties invested in the business. And if the business were profitable, which it turned out to be, they got a return of what they invested in the business and shared in the profit of the business. Now, there is no court in the world that could design a solution like that. And there is no court process that could bring the family talking with one another back together again, as there was in this particular case. And I use this example because it's such a magnificent illustration of the special artistry and skills that come out of a mediation process, as distinct from a winner and loser in court, ultimately many, many years later. Second, the monkeys. So the monkeys were, I don't know how familiar all of you are with monkeys. My wife and I have been to Africa on 6 safaris, 6 different times. But there's squirrel monkeys, little ones, and then there's big monkeys. And the big monkeys are called langur monkeys. I don't know if you've ever seen langurs. Langurs are like almost a small chimp in size. But when they show their fangs, they got incisors in there that'll scare the living heck out of you. So what we did is we brought in on a leash 6 langur monkeys, and they fanged out the little monkeys that just disappeared in a matter of a couple of weeks. And we kept them on a leash with their owners, their trainers, until we got rid of all the monkeys. And then we put windows, there were no windows in the mediation center when we first started. So the monsoon rains would come in, the garbage would swirl around, unbelievable. We put windows in the place. We had the langur monkeys. We set up a meeting place. And if you go to our website, there are pictures of some of these, which I think you'd enjoy seeing. A place where people could come and be safe and comfortable, and gave them access to the process. So the Langer monkeys, I now have a course in law school called Langer Monkeys 101. That was the answer for that particular solution. Any other questions?
I see Michael online has his hand up. Michael?
Thank you for your presentation and even more for the work that you're doing. I am wondering, so I understand that your methodology...
Michael, could you speak up a little bit louder?
Well, okay. I am wondering if some of your know-how could be used for, say, mediation of political or ideological disputes in our own country. Although this is a different area, but anyway, maybe there are some commonalities.
You're absolutely right. It's a great question. For those of you who might not have heard it quite as clearly, how do we use the mediation process in our own toxic political environment, much less in these toxic disputes? And it comes down, in my mind, to one word. And that word is civility. I think what is beautiful about the mediation process is that you learn to agree to disagree with the other side. As I say to the parties before I go to a mediation, you're not going to convince the other side they're wrong and you're right. You're going to agree to disagree about who's right or wrong. And we're not going to spend a lot of time, if any time at all, but we're going to respect what the other side feels that they think is legitimate. And we're going to be able to disagree and move on to focus not on the disagreement, but on a resolution. Now, there is a group, for example, I think they're called, maybe somewhat, you're familiar with it. It's called Better Angels. I don't know if you're familiar with this organization.
Braver Angels.
What is it?
Braver Angels.
Braver, that's it. Braver Angels. I just actually contacted them a couple of months ago. And I was really impressed. I watched some of the dialogue that they created. They had a dialogue between a religious figure, I think it was a pastor, who was speaking against, for gun control. And then they had a gun activist who had been brought up with guns. And they had the two of them talk about their respective positions through their moderated panel. And it was very impressive because they each had legitimate concerns and perspectives of what their rights were, whether they're constitutional, whether the right to be free from violence and safety and all the rest that's going on. And it was a very civilized exchange in which they were able to identify certain things, certain action items that they had in common to try and promote. Obviously, both parties supported nonviolence and supported the stopping of all these horrific killings that have been going on in the schools and so forth. And it was building on it. So the idea of a civil exchange where you respect the other views, even if you disagree, and look for common ground, to me has great application in our political environment as well in our social environment. Now, whether we are going to be able to find politicians who have the integrity to do this is a great challenge. And I will not digress on this other than to say, I was very skeptical, of course, throughout the whole Trump administration. I hope I'm not offending too many of you, that this would ever happen again. But Trump, Bolsonaro in Brazil, Orban in Hungary, I could go down the whole list for you, okay, of all these populist folks that have just fed this toxicity. And I do believe with what we've seen in the midterms that we are appealing more and more to people's desire to restore and build a rule of law in this country. We came this close, I mean this close, to a true coup in this country the last election, last presidential election. And but for whether you like him or you don't, the courage of one guy who stood up to him and just refused to disregard his constitutional obligation, not somebody I have any sympathy for in terms of his political or his religious beliefs, frankly, but he stood his ground, it would have been catastrophic in this country. And it showed us how vulnerable we are. So I think the braver angels. I think the civil dialogue and volunteering for those kinds of efforts and those kinds of exchanges, and particularly what we've seen in the midterms, give me reason to hope there is a place for all of this. Yes, ma'am.
Let me bring the microphone.
Yeah, I've been sitting here thinking about the kind of people that one finds in law school and thinking that they have sort of what I call the polemic personality. They basically live to argue.
Right.
And it's very, you must find that there are some people that are really not suitable for this work because of that bulldog kind of nature.
Right.
Yeah, I wondered about that. Then so the other question I had was around the subject of abortion.
Mm-hmm.
So is that something that your group would consider taking on? And how would they do that? And how would they, because, you know, that's a really difficult one.
Controversial question, sure. Good questions. Let me take them in order. First, with respect to the adversarial nature of law school training, I'm happy to report to you, certainly in the United States and in many of these countries, we've now worked with several of the law schools in Brazil and India and other places. They are introducing coursework in law school on ADR, alternative dispute resolution, on mediation, which is just, it's fantastic in terms of what's going on. And even people who have, like I did, the fangs and enjoy the competition of an adversarial proceeding, we've seen them grow to appreciate the beauty of the mediation process and providing this as a client service for which you can bill very handsomely. So we are seeing that coming up now in our law schools. And I must digress a little bit further, just to give you an idea of what's going on. In the United States, 35 years or so ago, maybe 40 years ago, of the number of cases that were filed in court, let's just take the federal court system, although it's very similar in the state court system. Of those cases filed in court, what percentage of those cases went actually to trial? What would you guess?
10%.
10%? Too low. This is 35 years ago, a little bit more. A little higher? 50 is a little too high. About 35%. 35%, 1/3 of the cases that were filed in federal court actually went to trial. And that's why they got backed up in our federal courts and various programs were created. Now, fast forward to 2022. Of those cases that are filed in federal court today, what percentage of those cases go to trial? 20%. 5%. 50%. Oh, 15. You're all too high. What did I hear? Less than 2% of the cases. What's happened to all those cases? Why are our federal judges fighting? They fight over cases now when they get one that goes to trial. And that's because ADR and mediation has become such a popular and successful process that for example, before I retired from my Silicon Valley firm where I was for 17 years, I used to get calls. I want the best bulldog lawyers and go up and beat up the other side and win the case. And I don't care what it costs. I started getting calls in my later years. Who knows mediation? Who can get me to mediation? Who can get the case resolved? And who knows the best mediators to get a successful result here? We get very savvy clients in Silicon Valley and in other kinds of disputes. In marital disputes now, we have marital lawyers who specialize in resolving. It's a special kind of mediation, a special kind of conciliatory process in which the lawyers take the cases to mediation and they refuse to litigate the case. They represent the parties in the marital dispute. And they will not take, if it doesn't settle, they will not handle the litigation. It's called collaborative mediation, very successful process. So what we've seen is this dramatic drop in cases going to court, this dramatic success of ADR. Also, arbitration has been used, which is more of an adversarial process, but a lot of arbitration that's going on. as well too. And our state courts, it's less than 3% as well. State court cases going to trial today are less than 3%. So this speaks to the tremendous success of the process. Did you have another question that I didn't answer?
Yeah.
Oh, abortion. That's right. Let me say this briefly. The answer that is we do not get involved in those kinds of very controversial political issues, but we have had cases in which a woman's right to her body and her body processes and to decide whether or not she wants to have children or not have come up in custody matters. And we have been involved from time to time, not a great deal of cases, a lot of cultural issues involved here, but in resolving, reaching resolution on a process that would allow the parties to voluntarily resolve the issue of whether they're going to allow an abortion or not, and under what circumstances. But we don't advocate. We are not a political advocacy organization in that sense. Yes,
Masuma.
Yeah, you already answered Diana's questions, but it's a similar line of thought. How do you overcome the socio-political and traditional aspects of each culture, as well as the law is different, vastly different in each country?
right.
And being from the Western civilization, Western culture, and you're going across the globe, how do you address them and make sure they understand you and you understand them as well to mitigate the issues?
That's an excellent question. And I'll give you all too brief an answer, but it's such a good question. I want to make sure I address it. The answer to that question is the key to our success, or frankly, our failure if we don't do that. Because if we come with a preconceived notion, this works in America and this has got to be good for you, I can tell you, you're going to get kicked out when you're rearing faster than you got there. And it took me a long time, for example, in India, a very independent and proud country, post-colonialism, coming as an American with our ties to England, to build a relationship with these judges that they really trusted what we were doing. Were we just promoting an American political agenda, or were we really interested in the country? And I'll use that example. My first trip to India, I got a scholarship when I was about 20 years old. And I worked in a small village, which, by the way, I reconnected with in my last trip to India. It was a phenomenal experience 40 years later. But let me not digress too much on that one. When I went to this village, Bellator it is called, I noticed they had what was called a panchayat. Panchayat means 5. And what it is, and this is relevant to your question in just a moment, is the 5 elders of a village would gather around a tree on the edge of the village, usually in a kind of a dirt sitting area with some sitting places to sit. And they would listen to the dispute going on in the village. Whether it's a marital dispute, a property dispute, physical abuse, a charged theft, or whatever it may be. And those 5 would deliberate what the merits were of the dispute and would then urge the parties to adopt a particular solution to the dispute. It was a form of mediation, really, of trying not to say who's necessarily right or wrong, although sometimes they do some arm twisting, but really to have the elders share their perception and use their influence in the community to reach a resolution. So when I first started working in India in 2003, excuse me, it was the panchayat model that I spoke to everybody, and it was well known by the high courts, the middle level courts, and the trial courts. They knew about the panchayat system. And I tried to model the first mediation center by that system. And that way it was culturally familiar to the people that were there. They could understand it, and they would be willing to sustain it after we were there. So that's how we tried to build it. And of course, you're absolutely right. It's very different in Brazil. It's very different in Bulgaria. It's very different in Croatia. All these countries have their own methods. Some in northern India, they've got a very strong tribal history there, that if you try to impose something that was our concept of a civilized mediation program on the tribal mentality that was there, it would fail completely, or it would fail as soon as you left. So tailoring it in that way, that's why the first part of the work that we do, which is to go and first learn what works and what doesn't work in the country, is vital to our success in these countries. Okay, so that's the. Did you have a second question, or?
Yeah.
That covered your question. Good question. Thank you.
Yeah. Carl, did you have a question?
Yeah. Yeah, I just wanted to make a comment. I actually had 2 mediation sessions. I want to make sure I stay away from the speaker. I had two examples of that, and one of them was an example of what you said. There were 2 trained mediators in a divorce, and it went really smoothly. It worked really well. Then I had another dispute. It was a business dispute where the guy was absolutely irrational about any mediation at all.
This is one of the parties or the mediator?
One of the parties.
One of the parties.
And I think that the mediator wasn't trained well enough, because he came back to me and said, "What did you do? Rape this guy's sister?"
Yeah,
that's what he said to me.
Yeah,
that's intractable. So what I was going to ask you is, can you just give a couple of the ideas of the tools that you actually use to bring such people into the fold?
Sure. Also a very good question. One of the arts, which is foreign to most of we lawyers, particularly those of us who have been litigators, to put it in nice terms, that we learn about in mediation is the art of active listening. Or to put it in not such nice terms, is stop talking and learn how to just shut up and really listen actively. It's a term of art that we use in our field, active listening. And it's used in other fields as well, too, certainly in neurosciences today. And this business of compassion that Roy Speckhart spoke about in his book, this ability through listening and understanding, not necessarily agreeing or disagreeing, just opens up possibilities to deal with parties that their pain needs to be heard. This is exhibited in one technique, by the way, that I have found. My field was mostly employment law over the years. The employment work with a lot of wrongful discharge cases and sexual harassment cases and discrimination cases. One of the most powerful tools in representing companies that I found was the tool of an apology. And there are all kinds of apologies, you know. There are actually many articles written about. There are kind of mechanical apologies with you just state it and it doesn't convince anybody. There are apologies in which you don't accept that you've done anything wrong, but you express a real empathy and sincerity about your regret over the pain somebody has suffered. And then there's apologies where you acknowledge you've done something wrong and you want the other side to reach some resolution of what the dispute is all about. So all of these are techniques. And the way it's put in the terminology of most of the professors of mediation is you try and use active listening to get at what the real underlying issue is in the dispute. What's really motivating the parties? Is it money? Is it loss of prestige? Is it loss of their job, their reason for being if they've lost a position? Is it a woman that's felt violated and never had a chance to be acknowledged for what she has suffered, or somebody held accountable for something that's been done wrong to her? Is it somebody in a property dispute, like the family that we dealt with for all those years? They dealt with the dispute for all those years, that is fighting over different uses of the property, each of which is legitimate. But until we could determine what they wanted to use the property for and how we could accommodate it through a lot of active listening, we couldn't come up with a solution that would really work. So those are the tools. Now, in addition, I'll just mention a couple of other things and kind of answer it with that, and be happy to talk to you further if you want afterward. There are certain techniques that we use where you reach impasse. Almost all these cases reach impasse very early on. So a skilled mediator knows how to, what we call, expand the pie. If one party wants a certain amount of money, the other amount doesn't want that much money wants that much more, or there's a property interest that's involved one way or the other, and they reach loggerheads very early on. It's up to the mediator not to propose a resolution, but to create options for them on new ways to look at the problem. Let me give you just one classic example of how a mediator can use this. If somebody wants their job back, and they've been wrongfully terminated for whatever reason, they feel they've been racially discriminated against, gender discrimination, whatever, or sexual orientation, whatever it is. And there's a certain amount of money that they want, and the employer doesn't have that amount of money, but wants to get the case resolved. What are the options that are out there? Well, one of the options we come up with, of course, is that instead of a flat payment of a large amount of money, it might be scheduled payments over a year or 2 year period of time. And it might be more money rather than reinstatement back in the job, or it might be reinstatement back in the job or another job with another supervisor that isn't a problem, or another part of the company where not as much money has to be paid. So we're constantly looking to use those tools to create a resolution. Lastly, I would mention one other tool that many we mediators use is what's called a mediator's proposal. I'm smiling because there's so many aspects of this that I'd love to talk to you about, but out of respect for your time, I'll just talk about one, which is a lot of times you get the parties so close that they can't close it, even though there may be in a dispute, they might have been separated by hundreds of thousands of dollars. You get it separated by $15,000 to $20,000, which in my cases is not a great deal of money, but you just get dug into your position, you can't get a new. So we have a technique called a mediator's proposal. And this means that when you've built the respect of the parties, you ask whether they're willing to participate in a process called a mediator's proposal. Now, you have had confidential conversations with each side. In many cases, you can't share with the other side the nature of the confidence, but because of these confidential conversations, you know there's a little bit more room to give more or accept a little bit less, but you can't tell that to the other side. And you get a sense with that gap that if I push each side a little bit more, not to the center necessarily, but one direction or the other, when they know it's all over, they may agree to it. So this technique of a mediator's proposal is when everybody's ready to walk out the door, they're exhausted, you've been on the Zoom thing for 6 hours, everybody is tired. I will offer to do a mediator's proposal. I'll explain what the process is. And the beauty of the process is nobody knows in the mediator's proposal if the other side rejected and you accepted. So you give the proposal to both sides. Each side will tell you, the mediator, confidentially whether they accept or reject. If they accept, you hold that until the other party accepts. If any party rejects and the other party is accepted, they only know that one party is rejected. So nobody loses face. And it's a very, very successful technique to try and get the parties where they're really locked in. So let's give you an idea of some of the techniques that come into play.
Oded, I see your hand has been up for a while.
Oded, you muted.
Oded, yes, muted. You're still muted, Oded.
Okay.
There you go.
There is two options for business legislation. One is going to trial lawyers or go to mediator. In the past, mediator don't have to have a law degree and they can just talk with the parties. Why they go from trial lawyers to mediator? Because lawyers today making more than $1,000 an hour. Lawyers try to make this issue extended for many years. So they have lots of income during those years. What happened now is mediator was not lawyer at the beginning. So it was very, cost-effective
Right.
way to do it. Right. Now, more and more lawyers come to this mediator business. And this would make the mediation much more expensive. And actually what going today is my lawyer talked to the mediator, to the other lawyer. That means the parties again need for lawyers, one for each side and 2 lawyers for the mediators. So this again make all this mediation expensive again. And I see in the future that people go back to the court rather than to the mediator table because it will be full with lawyers. That
Sure.
income.
So let me get, and I'll answer this, I think from the time perspective, probably this will be the last question I'll be able to answer, at least with you together. I'm happy to talk to you afterward individually. It is an issue, but I can assure you that even though certainly when I served as a mediator, the expense of the mediation was nothing compared in these disputes to what it would cost in litigation. There are exceptions to that it can. Arbitration is an exception because arbitration, you go before a private, basically a private judge, and that tends to be very adversarial, can be very expensive. Even though you can't appeal an arbitrator's decision, it's final, but it is adversarial. Mediation is really overwhelmingly less expensive because it's usually one session or maybe a few sessions over a short period of time. Most mediators that I know of, and I'm quite familiar with the mediation community, not only in Northern California, but in the United States, their fees are nothing compared at all to the nature of the cost of the dispute. It's a pittance. There are very, very high visibility, big dispute mediators who charge a great deal of money per day. Certainly upward from $20,000 to $25,000 a day is not unusual, but those are extraordinary exceptions, and they're only in very big items in which the fee doesn't make a difference. You're talking about many millions, if not more, of dollars that are involved. But in the garden variety mediation, the mediator's fee is not an issue. Number two, many mediators are willing to negotiate their fee in order to accommodate what the parties are. I know I certainly do, where I have parties that are not well off and able to do it. And three, I participate in a voluntary pro bono program with the federal courts that my time is all voluntary that we do for mediators. That's available in both federal and state courts today. And lastly, in response to your question, yes, there are many mediators now that come from different backgrounds who are not lawyers. Most are lawyers or have a legal training. But we have found, for example, engineers are phenomenal if they've been trained. If they get it, and they often do, and they're properly trained, they come in and handle these construction disputes and engineering disputes, and they're phenomenal. And they have a lot of respect for the parties. In merger acquisition, stock transaction deals, bring in people who are venture capitalists, who are people that are familiar with these sophisticated business matters, and they serve as a mediator. They garner a lot of respect, and they can be very, very effective. So by no means does one need to be a lawyer, although I will say where there are key legal issues, it's very helpful to have a lawyer that's there really understands the issues, that can speak lawyer to lawyer about what is a realistic settlement, a reasonable likelihood of success. And I will close by saying that in my case, I have found I will not do a mediation without somebody representing the parties, be it a lawyer or a family member. I find that in these cases where there's not a lawyer present, the parties are so emotionally engaged, and I have nobody that can really talk them into a more sober and realistic assessment of what their likelihood of success or failure is, and to move them towards a resolution. I find that really very, very hard, particularly in termination cases or sexual harassment cases. So I only do cases when I'm asked to do a mediation where there is a lawyer or a representative of the party who can give good counsel to their client in the process, which normally is very reasonable in its scope. So with that, I should conclude. Let me thank you once again for the opportunity to come and speak with you. You've been a great audience, and I'm really glad to do it in person. It's great to see live, breathing people, as well as those of you who've joined me on the camera here. And again, congratulations on the work in your chapter. I think it's fabulous to see you continue from year to year. I wish you success, and I look forward to future opportunities to talk with you as we progress over the years. And I'll be happy to answer any further questions after we conclude the session. Thank you very much.